Now change gears and go to the Supreme Court, where the Supreme Court has actually upheld the election of Anwar Aloy Tip Tip Lamu Senator, Wanjiko Kibe of Gatundu North, Kagongo Bowen of Marquette East, but Ahmed Kalosh of Wajir West has actually lost his bid. Let's listen in.
Again, although a much longer judgment, appearances. Mr. Otachi, Orengo Senior Counsel, Awele, Odhiambo, Isaac, you are appearing for the second and third respondents. Thank you. Although longer than the other two, I will still summarize it in the way I've done the other two judgments. At pages 1 through 3, all the way to page number 21, we summarize the cases before the High Court, the Court of Appeal, and the submissions before this court. We have then distilled the following 7 issues as following for determination. The first question is jurisdiction. The second question is whether the appeal before the Court of Appeal was competent. Number 3, whether the Court of Appeal admitted in failing to admit the video evidence that was supposed to be tendered in the High Court. Issue number 4, whether the Court of Appeal acted in excess of jurisdiction in delving in matters of fact, contrary to Section 85A of the Elections Act. Issue number 5, whether the Court of Appeal misdirected itself in the interpretation of Article 81 and 86 of the Constitution. Issue number 6, whether the first respondent discharged the burden of proof in the appeal before the Court of Appeal. And number 7, the reliefs available to the parties. On jurisdiction, we have looked at Article 163.4a, the case of Ali Hassan Joho, Lawrence Ndutu, and we have quoted in extenso the guiding principles that were set by Chief Justice Mutunga in that case. We have also reproduced parts of the judgment in Frederick Otieno Outa, Evans Kidero, and Waititu, and we have come to the conclusion that since this appeal touches both on Article 159.2d and interpretation of Articles 81 and 86, we shall assume jurisdiction to that extent only. On the second question of the competence of the appeal as regards the notice of appeal, we have reproduced at paragraphs 33 and 34 the judgment of the Court of Appeal in the way it rendered itself on the notice of appeal. The case of Kashim versus Bashir, a New Zealand decision, we have looked at Joseph Raz in the rule of law and its virtue in a paper entitled Rule of Law, Judicial Independence and Judicial Discretion. We have looked at HLA at Hat, discretion in Harvard Law Review, and quoted him in extenso. Daines Morevi, Daniel Kimani, Basil Criticos, TSC, and we have looked at rules 5 and 6, and we have come to the conclusion that notwithstanding the divergent positions taken by the Court of Appeal post-2017, for example, in the case of Simeon Lesirma and Musa Sirma, we have said that we don't see any reason to interfere with the discretion of the Court of Appeal in the way it handled the notice of appeal question. On the question of the video evidence, we have looked at the powers of the appellate court in as far as it can delve into matters of law or how it should treat matters of fact under Section 85A. And the Munya 2 case is the case classicus on that question. We have also looked at the case of Honorable Mohammed and Abdullahi, IBC versus Stephen Mutinda, Housing Finance versus Wafubwa, Kenya Post Authority versus Mitubel, and we have come to the conclusion that looking at the way the Court of Appeal handled the video evidence, we hold that the decision of the Court of Appeal not to admit the video evidence or even evaluate it was in excess of discretion as under Rule 29(1)B of the Court of Appeal rules, delimited by Section 85 of the Elections Act, and the party was also bound by the pleadings of the petitioner in the Court of Appeal before the Court of Appeal, which had no such prayer. And therefore, we deem it unnecessary to overturn the finding of the Court of Appeal regarding the video evidence. Did the Court of Appeal then overreach itself in the interpretation of in the application of Section 85A? We have looked at its decision on that question. We have looked at Munya 2. We have looked at Article 81 of the Constitution, and we have come to the conclusion that the Court of Appeal did not act in excess of its jurisdiction, and they acted in accordance with Section 85A and our decision in Munya 2. And therefore, the Court of Appeal cannot be faulted in the way.
Listening to proceedings coming from the Supreme Court about various election petitions, and we are expecting more ruling on the various petitions in court to come throughout the day. So far, what we know is that the Supreme Court has upheld the election of Anwar Loitip Lamu Senator, Wanjiru Kibe of Gatundu North, Kangongo Bowen of Marquette East, and Ahmed Kolosh of Wajir West has actually lost his bid. We know that Embakasi MP, that is Babu, we know is awaiting his fate, and we shall definitely keep you updated on the same. But